Welcome everybody to Burns Levinson's webinar, IP and Cybersecurity. We're going to cover some issues of data misuse. I'm Howard Susser. I'm chair of the IP Litigation Department of Burns & Levinson, and joining me today is Brooke Penrose, who's practices in intellectual property and copyright, trademark, and soft IP. I'm going to give you a brief overview of the program. And then I'm going to hand it off to Brooke to do the first half, and then I'm going to come in. And then we're going to have a question and answer period. Hopefully we'll have enough time, and we will definitely follow up with answers to any questions you may have that we don't get to by email. So today's program is going to look at a couple of main areas. First, the practical considerations for handling internal security threats where they arise. Some proactive steps you can take to mitigate the internal threats, understanding what your assets are, adopting appropriate documentation, safeguards. And then that part is Brooke. And then I'm going to talk about enforcement options. What do you do if there's been a breach, notwithstanding your proactive steps? What kind of civil actions can be taken, and what happens in those kinds of lawsuits? And then after that, we'll open it up for any questions you guys may have, which you can do in the Q&A button. And we'll try to get as many of those done, and we'll follow up if we don't have enough time. So without further ado, I'll hand off the webinar to my colleague, Brooke.
Awesome, thanks, Howard. Before we dig into this, I just wanted to remind everyone of a few key points about this webinar. First, we're focusing on insiders, by which we mean folks that you've actually authorized to access data for a specific use, such as your employees. Data misuse generally happens when folks use data that they're authorized to access, but beyond the scope of that authorization, or in some other way that's inappropriate. Sometimes data insiders misuse data in a way that's malicious, fully understanding that what they're doing is inappropriate. But innocent insiders, such as victims of phishing attacks, also expose an organization to significant risk. So bear in mind that insider data misuse isn't always meant to mean that the insider is a bad actor. In addition, Howard and I are discussing a variety of data misuse flavors in this webinar, ranging from breaches of personal information to employee misappropriation of company trade secrets. All of these activities expose the company to some degree of risk if data is misused or exposed to an unauthorized third party. So bear in mind that throughout this webinar, we'll be discussing an organization's data, both in terms of it being a valuable asset worth protecting, as well as a potential source for liability. To begin, there's never really a bad time to take inventory of your data handling practices and consider their effectiveness. However, there are a handful of key moments in the life of an organization where careful examination and evaluation of your data handling practice tends to become critically important. Going through some of these top triggers, then the most obvious is if you suspect a data breach has actually occurred. This could be triggered by detection of unusual activity by your IT department, or because members of your business team become suspicious of some operational hiccup, or because a third party alerts you. Which brings us to the next common trigger for looking at your data handling practices is when a third party actually complains to you. This could be due to a government investigation into the company's personal information handling practices, particularly if they involve consumers, or allegations from another organization who either believes that they have inadvertently received your data or believe that you have wrongfully received its data. Third, looking at corporate transactions, especially acquisitions or funding rounds, those can also trigger diligence questions about an organization's data handling practices, which can ultimately impact valuation. Finally, looking at changes in your relationship with your employees, including departing employees and/or employees who are moonlighting and no longer work exclusively for your organization. These can prompt you to evaluate whether appropriate safeguards are already in place to ensure that employees' new working relationship isn't likely to expose your organization's data or otherwise provide an opportunity for the employee's misuse of company data. All right, went in the wrong direction there. All right, so what are some strategies surrounding data management that organizations should consider when developing their internal policies and practices? There's really no one size fits all when it comes to data management best practices, and ultimately the structure and complexity of your organization and the nature and sensitivity of the data you're handling will influence what a reasonable approach looks like. But developing and improving your organization's data developing and improving upon your data management program generally benefits from first understanding your organization's data, second, developing written policies, and finally, translating those policies into implementing operational safeguards. So before attempting to tackle policy and procedure updates, it's critically important to get your arms wrapped around the organization's data. This means understanding the who, what, where, when, and how, why of your data. You simply cannot draft meaningful policies or implement practical safeguards before understanding what it is you're trying to safeguard. So digging into these guiding questions then, and in no particular order, this is what we mean by understanding the who, what, where, when, why, and how of your organization's data. First, you need to understand who has access to what types of data. You should also understand whether or not having access to a set of data means the person has no official authorization, but technically could easily access it anyway, or whether there are technical and operational barriers to prevent access of the data by any unauthorized people. In general, and particularly with sensitive trade secret data or personal information, access should really be granted to individuals on an as necessary basis. As Howard will discuss later, in order to protect data as a trade secret, it's critically important for the organization to be able to demonstrate that it's actually been treating the data as a secret, which can be undermined if it's been providing open and unfettered access to the data. In addition, you need to understand what categories of data your organization is maintaining. This could include personal data, such as contact details for customers, personnel files of employees, proprietary formulas, methods of conducting your business, and the data of your organization's clients who have entrusted their information in your care in order for you to run your services. The category of data and its relative sensitivity will be a key driving force for informing your policies and procedures. The where of your company's data will also influence its data handling approach. By where, I mean both, is it stored locally or even non-electronically in physical files or in the cloud? In addition, we're also talking about geographic locations of where the data is stored, including server locations. Locally stored data may provide certain advantages in terms of being able to control access, but cloud storage may provide a path for easier access monitoring. You should also pin down when and how the organization came to hold its data. Its security obligations may differ depending on whether it acquired the data from third parties, such as contractors or its clients, or in the case of personal information from individuals versus data that was developed entirely in-house. For example, there could be contractual restrictions in service agreements or representations made to individuals who provided their personal data for your use. Finally, for any data, consider why you're holding on to it. That is particularly important for data containing personal information and third-party owned information where there may be additional liability to these parties for data misuse. In order to justify an organization's continued acceptance of this risk, there should be some meaningful benefit to continuing to safeguard it. All right, so now that we understand the ins and outs of your operation, your organization's data treasure trove, and are ready to dig into putting together some meaningful policies to safeguard this data. A typical data handling program will include a variety of written policies depending on the nature of the organization's data. First, we're going to look at privacy policies, which relate to how personal information will be handled by an organization. Then we'll cover data use and security policies, which typically cover how insiders are authorized or restricted from interacting with an organization's data. These policies may be covered in an employee handbook as well, which may also address restrictions such as non-competes, non-solicitation, and confidentiality obligations. Alternatively, these policies may exist as standalone policies. Next, we're going to talk about intellectual property assignments. And finally, we'll talk about typical provisions that address data handling obligations in third-party agreements. All right, so if your organization processes personal information, it most likely is required to have a publicly posted privacy policy disclosing how it handles the personal information it collects. The granularity and the type of disclosures required are going to vary depending on the laws that apply to your business. But the short of it is that there's a general obligation to provide fair and non-deceptive information to people about how you will handle their personal data. Typical topics covered in a public privacy policy are going to include things like what personal information is collected, how it's collected, how it might be used by your organization, and who you may share information with. Additional disclosure requirements may kick in depending on whose laws you need to abide by. Many of you may already be familiar that if you're collecting personal information from California or internationally, there are additional disclosure requirements under those laws. You will also probably be required, again, depending on the laws that apply, to provide a summary of the user's rights. For example, if you send marketing emails, federal canned spam laws require you to provide users with the ability to opt out of future marketing messages. Finally, as a best practice, you should include contact information for individuals to ask questions about the privacy practices and or file complaints or exercise their rights. In addition to a public-facing policy, you should also have an internal privacy policy that clearly informs employees how to handle personal data. These policies are generally far more detailed than a public policy and include operational guidance, not just principles. It may also be helpful to include a mission statement reflecting the organization's commitment to personal privacy, just to set the tone of the corporate culture. The policy should also designate individuals within the organization who will have roles with respect to privacy compliance. It should also detail the operations to implement the public-facing privacy policy, including designated who within the organization will receive and respond to complaints. There should also be accountability for noncompliance, so the policy should include disciplinary action for any noncompliance. Finally, regular job-specific privacy training should be required when appropriate. Okay, so beyond personal information security, best practice is for organizations to also have internal data security and handling policies. Sometimes these written policies are expressly required by law, such as Massachusetts state law, if personal information about Massachusetts residents is involved, or if the organization needs to comply with Gramm-Leach-Bliley at the federal level. In both cases, these policies may be referred to as written information security programs, or WISPs. Typical topics covered in these programs include an overview of the data of the organization's data inventory and sensitivity classification system. It may also outline the roles and responsibilities of data security personnel within the organization. It may also include data retention schedules as well as password and access restriction requirements. It should also include a breach response plan, which Howard will describe later, but which generally includes things like an investigation plan as well as mitigation and containment plans. The policy should also address how data should be handled upon an employee leaving the company. Finally, there may be company-specific topics that vary depending on the nature of your business, such as policies regarding employees bringing their own devices and encryption requirements. In addition to managing how data is maintained, you should also think about new data onboarding and building your data handling practices. Organizations need to be aware of how they structure their intellectual property assignments. First, in terms of copyrightable works, which may include things like software or graphics, there's a common misconception about the term work for hire. The term rarely applies to non-employees. So if your organization gets help from non-employees in creating something that might be copyrightable, it's important to get a written and assigned assignment of rights rather than assuming that if you paid for it, you must own it, or that you could just call it a work for hire to effectuate the transfer of ownership. Employee creations within the scope of their work, on the other hand, typically do require as works for hire. So you might be able to address how the organization will treat copyrightable employee creations in your employee handbook. The assignment of patentable inventions is a bit trickier. Patent applications can all be filed in the name of an individual and later assigned to the organization. With cooperative employees, this may not be a problem, but if an employee who created an invention later becomes uncooperative in executing the correct documents during the patent process, there can be complications. However, the US generally recognizes shop rights, which is an implied license to an organization for an employee-created invention under certain circumstances, regardless of an express assignment or license. Still, the best practice is to have employees who will be inventing as part of their core job responsibilities execute something called pre-invention assignments, which require fairly specific language that really could be its own webinar topic. Any assignment for work for hire employee policies should, any assignments or work for hire employee policies should be reasonably clear so creators understand the scope of rights that they may be giving up. Finally, make sure that employees are provided with policies regarding IP ownership before they begin work on creating content and inventions for you. Clawing back ownership can be challenging after the fact. The last category of documentation we will discuss is third-party agreements, such as service agreements. Depending on the nature of the service and how much data each party has access to from the other party, the detail of these agreements the detail these agreements go into with respect to each of these topics may vary, but typically the relevant provisions designed to safeguard a company's data include those listed below. For example, the reps and warranties may include obligations to comply with applicable data security and privacy laws. There may be either an intellectual property assignment provision and/or a provision defining the scope of each party's IP ownership rights. Related to this, there may be confidentiality obligations between the parties. You should also make sure that the scope of any authorized data use is clearly defined, which should include obligations to destroy or return data once the engagement is terminated. Non-solicitation and non-compete clauses may be relevant depending on the nature of services. Increasingly, we're also seeing data breach and misuse notification obligations, sometimes even audit rights provided for so that the party providing the data has the ability to audit the receiving party to check for data misuse or non-compliance issues. Finally, indemnification provisions are increasingly common, as are carve-outs for any liability limitations as applied to data breaches. All right, so you understand your organization's data, you've drafted a wonderful set of policies meant to protect the data, but none of this really matters if only a handful of people at the organization are aware these policies exist. So the final step is to implement technical safeguards, physical safeguards, and operational safeguards, as well as potentially adopting more of a data minimization approach with respect to personal information, which can often be just as much of a liability as it is an asset. All of these are just sort of ideas of steps that you may take to implement these sorts of safeguards. And as with the policy section, the approach will really depend on the nature of your organization, but under technical safeguards, you may consider things like technical access restrictions, password protection, other sorts of barriers. Any sort of storage, transmission security, which may or may not include encryption, a way to monitor activity logging, the ability for your IT department to remotely wipe devices if they become no longer controlled or lost by your employees, device locking requirements, as well as having a reliable data backup system. If your system becomes compromised, you can rely on your backups systems. Also think about physical safeguards. This may not seem as relevant now that many of us are in a remote work scenario, but many organizations still have physical files with whether it's personal information, such as employee information, formulas, trade secrets, whatever. So watch for building access restrictions, be aware of your workstation security requirements, and particularly with any physical files that contain sensitive information, ensure that they're kept in a secured and locked area. Looking at operational safeguards, think through your employee life cycle. We talked about IP assignments and employee handbooks in terms of onboarding employees, as well as being aware of what sorts of data restrictions and procedures should be put in place when an employee no longer is terminated or leaves. Make sure that there's a breach notification procedure in place with an appropriate team. Depending on the nature of your business, you may also want to consider having a forensic analysis on retainer who can be quickly deployed in the event of a breach. Finally, if your business is the sort that may be targeted for ransomware, where if your system were locked due to ransomware, for a prolonged period of time, more than a couple hours, it could really have a devastating effect. Hospitals, for example, may be particularly vulnerable. If you're in a situation where you know that if you couldn't quickly solve a ransomware issue, you would just have to pay. A preferred method of payment at this point is often Bitcoin. So you may want to consider having some Bitcoin available if your organization was targeted with ransomware. Finally, this last topic on third-party and personal data minimization, to the extent you hold information and data that really isn't entirely the organization's, whether that's personal information or information that you are keeping on behalf of your clients, it may be helpful to approach it with more of a less is more. Don't retain that information unless there's a really useful purpose for it. So look at your data retention schedules. To the extent that you have third parties that may have access to this data, make sure that there's restrictive contractual obligations to ensure that they're only accessing that data in order to provide the services that you're asking them to provide. And be sure that you have a reliable system for individuals to exercise their personal data rights. Okay, now that we've explored ways for an organization to proactively adopt a practical data management program, Howard's going to walk us through response strategies once the organization suspects its data has been misused.
Yeah, that ransomware thing can be really incredible, where somebody comes in and shuts down your entire company, locks up all your data. And if you don't have backups of everything, you're completely at their mercy, because they will not open up your company, emails, financial, anything, until you pay considerable money. And the only leverage you may have is, we have the whole system backed up. It's going to take us a couple of weeks, but we're not going to pay your money. We just had a large publicly traded company deal with this, and it's very scary. So that's definitely an area to be proactive. Hopefully, based on our webinar and otherwise, you have a plan in action and a whole written documentation of how to respond immediately to threats. But here's some basic starting points that you may use. There has to be, you have to assemble a security response team. There should be people, whether it's head of IT and others, who are going to be immediately in charge of the gathering of data. You have to have a lawyer that knows how to navigate this area, whether that's in-house counsel, compliance officer, or outside counsel. And you want to consider managing attorney-client privilege and dealing with the attorney. And another benefit of having an attorney involved is you can protect these communications. A lot of companies will have a third-party vendor, investigator type company, forensic analysis company on retainer. You've already done the contract with them, so there's a breach, there's a big problem. You can call them and they come in and get to work, rather than send you a contract and ask for a retainer. So you want to investigate promptly. You want to look at all the electronic devices, emails, storage, servers. You want to look at ingress and egress and video surveillance, trying to figure out if it's an internal person, when this might have happened. There are ways to analyze USB plugins to laptops and downloads. You want to collect all of that information that you can electronically, and you want to target, you want to police the target's workspace and their laptops and other devices. And you want to document everything that as you're investigating. This is all possibly leading to a civil lawsuit or even a criminal investigation. So you have to kind of do a law and order kind of investigation of getting all of this data. When it's an internal person, you definitely want to look at revoking their credentials, their access to the building, the security plans, suspend their work with vendors if it's a third-party vendor where this breach occurred or this hack, and you want to make a backup of everything you have as fast as you can. Those are some typical responses. A lot of that would be in the plan, but if you don't have a plan, you can follow those things. Brooke is going to comment on this issue that this may trigger some reporting obligations.
Right. So once your organization understands the categories of data that have been breached or misused, it needs to understand whether applicable law or contractual obligations require it to report the incident to others. If the data involves sensitive personal information, such as social security numbers, financial account information, many, if not most states, require the Attorney General and/or affected individuals to be notified if the breach involved unencrypted personal information. In addition, if your organization is regulated by HIPAA or Gramm-Leach-Bliley, it may have additional reporting obligations to consumers, federal agencies, and/or law enforcement. Further, if any personal information involves to folks outside of the U.S., international data protection and privacy laws may require additional notification. So be sure if you see personal information is impacted by the misuse to contact your legal team. Finally, if the data that was misused doesn't belong to the company, for example, if you're a B2B organization and store data of your clients, and it's your client's data that's part of the misuse and breach, there may be contractual requirements to notify the clients.
Thank you, Brooke. Yeah, this webinar is covering hacking of personal data or some other breach, or maybe inadvertent disclosure even of people's social security numbers or bank accounts, or all kinds of things that can happen. And then there's just employees who take things that don't belong to them. And all of this is under the rubric of data misuse. And so some of these are going to lead to different ends in terms of civil litigation, or just kind of stopping the bleeding and then reporting it out. Once you've conducted a fair amount of the investigation to ascertain what's happened, what kind of data has been breached, what kind of trade secrets or source code or documentation or training materials, whatever it is, there are a bunch of decision points about how to confront this problem. And the first thing would be to confront the offender directly with a disciplinary action that of the company, like you're suspended or fired even. We are, as lawyers, are often called in to do cease and desist letters, and those go to the person who is suspected of conducting the breach, or persons. Very often this occurs in the context of an employee leaving to join a competitor or to start their own company. And so when appropriate, the cease and desist letter will not only be directed to the individual, but will also put the company on notice that this person you just hired may have absconded with something that doesn't belong to them. Sometimes the new employer is in league with them, and they hired them in a conspiracy to get information, or to go right up to what they consider the line, but what you consider a breach. You always want to bring forward the specific references to the contractual language, employee handbooks where appropriate, and say, this is a violation of your agreement or our employee handbook. This is what you've done that's wrong, and here's our evidence. I mentioned once or twice today that in most of these areas of data misuse, hacking, trade secret misappropriation, there are parallel criminal and civil actions. Criminal actions are very rare. They're usually where there's major industrial espionage for profit. So much so that a law enforcement agency would want to get involved and expend the resources to go after this. It's not just a small case between companies. It's a bigger deal, and the proof would be there to meet the very high standard of proof. But the large majority of handling of these things is in civil lawsuits brought in the courts of the states and the federal courts, including ex parte action, which is to take action before the other side is notified. Oops, wrong way. So legal actions can be taken for a variety of civil causes of action relating to an employee or other person accessing files, data that doesn't belong to them, that belongs to the company. Clearly, the breach of contract is a fundamental one. As Brooke said, almost all companies will have some handbook or written agreement of non-confidentiality, maybe even non-competition, about non-disclosure. So anybody taking anything that would be a breach of that. It can also have contractual clauses related to data that don't constitute trade secrets per se. Trade secret misappropriation is also a fundamental cause of action in the context of a data breach, and we'll get into that. There's copyright infringement if they've taken something that's protected by copyright, particularly any kind of code. There have been lots of cases where people will leave with training materials or other documentation that they might be able to use for the new job. There's also an act called the Computer Fraud and Abuse Act, relatively recent vintage, that was developed as an anti-hacking statute, but it has brought in to have a civil aspect of it as well as criminal, to go after data breaches and hacking and thefts that may not necessarily rise to the level of a trade secret, but are interrupting service, or maybe just somebody's doing some kind of vandalism to your system, but they're not really taking anything. The CFAA is available for those kinds of causes of action. And then there's a whole bunch of state claims that you can, and common law that are not non-statutory claims that you can throw in. Again, criminal law enforcement is available as well. I keep going in the wrong direction. So there's some major things to consider before you go about the civil action route. Now, you may or may not have told the offending party, the employee or the third party, that you know what they did. You might want to sneak into court before you let them know. But in any event, you need to do a standard amount of due diligence here. For you to go into court, lawyers have to do a reasonable good faith investigation. You may not have all the evidence, but you have to do an investigation that you can stand behind in the event that it's later turns out that you're wrong and you didn't have the full information. You have to gather what evidence you have that you can use in these proceedings. And you have to consider that the standard to get into court is there are pleading requirements. It can't be pure speculation. There has to be enough facts that your allegations have a plausibility. It can't be pure speculation. And so this is the part that you definitely need to work with lawyers to figure out what you have. Once you decide that you have a cause of action or several causes of actions and you want to get the courts involved, you have to pick where, and that can be state court or federal court. There are some causes of action, like the copyright statute is purely federal. So if you're going to bring a copyright claim because you think there's source code misappropriation that's been incorporated into a competitor, you might need to be in federal court. Then you have to pick what court. That's a venue issue, which also turns on where you have personal jurisdiction over the parties. And then you have to look at the applicable contracts that you may have that deal with this. There may be forum selection clauses that you've agreed to, or they have, where they may have now moved to California, but they've agreed that any breach of the employment contract, they will come back to Massachusetts if you happen to be here. You have to decide which parties to litigate against. Again, we talked about having an insider employee, but In most cases we see there's some level of cooperation with the new employer. They're certainly hiring away somebody they know is a competitor's employee. And so how much they know and how far it goes and whether they've incorporated material that they have reason to know could constitute a trade secret. Those are very different kinds of questions that you have to answer. And then there may be co-conspirators. There may be parties that cooperated with the person who retrieved the data. An interesting issue in litigation is that once you're in anticipation of a litigation, there is a requirement to preserve all documents, evidence, and especially electronically stored information. If you're shown to have destroyed any evidence, any ESI that's relevant to the case after the case starts, there could be adverse inferences drawn. What happens is a lot of companies will have an automatic document deletion procedure after 3 months or 5 months or 5 years. And if you want to, usually these cases happen very quickly, but immediately you have to shut down any document deletion, and you want to sort of get your arms around documents, as I said up front. One of the very common features in these types of data breach cases is to seek a preliminary order of a court to stop the bleeding or get your stuff back. Many are familiar with the concept of a TRO. And what that is a temporary restraining order. And you can actually go to court without notifying the offending party or the company and get an order of that court compelling that party to stop what they're doing, to preserve all their evidence, to not destroy anything, or it would be a violation of a court order now. And that would come with an order to show cause, and they have to show up, whatever, 10, 20 days later and explain themselves. And this can be converted into a motion for preliminary injunction, which is a more common avenue. And that involves both sides with lawyers litigating the issue of whether before we even have a litigation, are you going to stop them from doing anything based on our submission? And the typical prongs for a PI, which are the same as a TRO, are you have to show you're likely to succeed in the merits. You have a good case. You have some evidence that this person plugged a USB and downloaded confidential information. You have password protection, and they violated it. Whatever your evidence is, you have enough to show you're going to have a chance of winning. There's irreparable harm that if we don't stop them from disclosing this to other people or using it in the public, we're going to destroy our trade secrets, or monetary damages will never make us whole. And in a TRO, when you have to argue that you can't even wait for them to show up. It has to be immediate because that's the risk of damage is so great. The court has to balance the equities and then consider whatever public interest might be involved. A very powerful preliminary order is the ex parte seizure order. And this is rarely used, but in many cases it can be necessary. And this is to prevent the propagation and dissemination of the trade secrets or the tampering, or if there's some strong suspicion that there's going to be a destruction of this evidence, or they're going to leave the country, or some other extraordinary circumstances to seize the property, and that a TRO or a preliminary injunction wouldn't be inadequate. So you have to prove the above 4 factors, and then you have to show that they have the trade secret, and you have to give reasonable particularity of what it is, where it's on a thumb drive, it's on a laptop, this is vital, this is crown jewels, this guy travels to Europe all the time, and that she would likely destroy this once there's notice. Even the TRO, he or she would not honor the TRO and destroy the evidence, so there would be no proof. And if you get this, they'll send a marshal in to seize this, like a raid, open, knock on the door and come in and seize all the equipment. We've had cases like that, but they are rare. The last thing is that if the request hasn't been publicized, if it's already public information that there's this dispute and that you're going after this person, you lose your ability to do the ex parte seizure order. The first cause of action I mentioned was breach of contract, and then that's sort of like the main fundamental one that goes into all of these civil actions. And of course, there's the standard employment agreement, which ordinarily has confidentiality, non-disclosure restrictions. There can be standalone agreements that relate to non-competition that could be thrown in if you think they took some data and they went to a competitor, you can throw the non-compete in. If that competitor solicited the employee, or they brought others, or they brought customer lists, or you find out that the ex-employee is working with your old customer, there may be breaches of the non-solicitation of customers. In the case where vendors are involved, or distributors, other third parties who have access to your data, or and you have to look at those agreements, as Brooke mentioned, and that's why those agreements should have strong clauses protecting your confidential information and data. Contract terms in these various agreements, including the employment agreement, may dictate the process. You may have to consider putting them on notice with an arbitration clause. You may have to, there may be cure periods. And there also, as I said, there may be form selection clauses of where you bring your action. In most cases, we always say you start with the letter of the contract and you go from there. So trade secret misappropriation is often, I'd say, one of the most important parts of an action, a civil action, to go after a former employee in particular, or a party with which you've done some business and shared a non-disclosure agreement, a joint venture, and they took your stuff. There's a parallel state and federal system. Every state has its own trade secret rules and laws. And then recently, I think President Obama signed into law the Defense of Trade Secret Act, the DTSA. And so now there's a federal codified Trade Secret Act that allows you to go into court and you can assert some of those ex parte remedies we discussed, and then litigate your case to completion. There's some particular challenges in litigating trade secrets. One of the first things is you have to define your trade secret and then disclose it at some point. And so if you file a complaint in federal court and said, this guy or this company stole my whatever, and it's a trade secret and it's really valuable, you have to delicately describe what that is in a way that doesn't disclose it to the public. And that's challenging to do from the get-go. You have to have a complaint. So there are a variety of ways of protecting confidential trade secret information in courts. And what courts will do is, once a case is rolling, they'll set up a protective order. And the protective order says that the parties can file things under seal in the courtroom, which could disclose their crown jewel trade secrets, and only the lawyers on each side get to see it. And so it's a confusing and confounding process to litigants, because if I'm representing a company and we know the bad guys took something and they have a competing company, and my client wants to see how they may have incorporated it into their product, he's probably not going to ever be able to see that, because they're only going to disclose that material to me, AEO, attorney's eyes only. And conversely, I'm only going to show what our actual trade secrets are to their attorneys, and then maybe experts involved in the case. So it's a very complicated sort of risk analysis of getting into a trade secret case, is that you may have to open the kimono quite a bit and run some risks about inadvertent disclosure. But there are rules in place in all these cases to protect them. Sometimes it's a challenge to define exactly what the trade secret is. I'll discuss the issue of know-how a little later. Sometimes it's very easy. Sometimes it's just data, like a customer list, plain and simple. But sometimes it's an algorithm used for a workflow module, and not easily defined, and there's lots of them out there. And so the granularity for each case really depends on the facts, which is part of the due diligence and evidence gathering that needs to be done. So under the Defense of Trade Secret Act, as an example, the trade secret is defined as financial, scientific, business, economic, technical, or engineering information that the owner has taken reasonable measures to keep secret, derives independent economic value from not being generally known, is related to a product, service used or intended for use in interstate commerce, and it can be non-technical marketing plans, sales data, customer lists, information about customers. People often think of trade secrets as some highly technical thing. It could actually be a list of customers' cell phone numbers. So once you have identified something that you consider a secret that's been protected, the next question is did the person, the accused, misappropriate it? And there are two main kinds of misappropriation. These are the fouls that you can occur with. So some people will have trade secrets in their head. You have the head of software at a company, or she may know everything about the secret sauce in all of your software, and she doesn't have to steal a document. So there's different kinds of trade secret misappropriation. It doesn't always have to be taking a document or taking a USB upload of a thumb drive. Some of it can be just walking off with knowledge that you're not supposed to share. So acquisition of a trade secret by another person who has reason to know it was acquired by improper means. That would be the taking kind of stuff, right? That would be grabbing some materials or electronics or code or schematics, training materials, customer lists, things that aren't necessarily completely in your head. And then there's disclosure or use of material, of information that you may have in your head about how the company works, about their business practices, about their marketing strategies. Either of those things can be misappropriation under the trade secret laws. If misappropriation is based on the disclosure of use, there's also carve-outs for people who didn't know that they had obtained something that was a trade secret. And so you need to look at this inadvertent or accidental. So for instance, somebody comes over from another employer and joins your company and suggests all these ideas for tweaking the software or the physical line. That may or may not have come from their prior company, but once a new entity becomes aware that some of this is proprietary, then they have a duty to not use it any further, unless there's been a material change in position and it was innocent, and that is a rare occasion. So for trade secret cases, you have the full gamut of injunctive relief available. You can go in for ex parte TRO, seizure orders, a preliminary injunction, and you certainly can get a final permanent injunction at the end of the case. You can get compensatory damages for your actual loss, or the unjust enrichment of the other party from using your trade secret or confidential information. Your actual loss could be your out-of-pocket losses from dealing with this, or business you lost from this disruption or the theft. Sometimes it's hard to peg down that damage, and the laws provide that there could be a reasonable royalty calculated for the unauthorized disclosure. Sometimes there's a disclosure but not a use, and saying, okay, well, the guy took it, he's showing it to people he shouldn't, but that's it. Well, what's the monetary damage of that? So you have to construct one, and one some courts will do is to create a royalty. Well, this is what it would cost if you wanted to license this material for a period of a month, and that could be the damage. Profit disgorgement is available if you can tie the theft of the data or the information leads to a product or profit by the offending party. You may be able to get a court or a judge to disgorge those profits as part of your damages. And then there's this notion of Head Start damages. Once, sometimes there's an occasion where the party steals some trade secrets, confidential information, and about a product that's going to come out but hasn't. And once that product comes out, it's going to be in the public domain, and it's not a secret anymore. Well, if somebody steals something or gives it to another party and they get a head start, a judge can fashion a remedy that says, you're going to wait 6 months after this becomes public before you can start a product in this field because you cheated. There can be exemplary damages or punitive damages if the acts are deemed willful or malicious. You can get attorney's fees if you can prove it's bad faith and willful. And as I mentioned earlier, there's a full gamut of criminal, state and federal criminal statutes for violation of trade secrets. Ordinarily, this relates to industrial espionage, big ticket items. There's a burden of proof in criminal cases of beyond a reasonable doubt. That means you have to convince district attorney or whoever to take up this case, that it's worth the expenditure of resources, and there's enough evidence where you have them dead to rights. One of the main defenses of a trade secret case, which I think is worth talking about because it's so fundamental to the Brooke's presentation about protecting your stuff in the first place, is to take extra care to make sure what you consider to be your trade secrets are really secret. I've been in a case where they had a plant that had a fence facing a road, and the question was whether people walking by could see enough in to understand that how the system worked. And even though the employees were signed confidentiality agreements, there was like this way you could see in, and it was argued that blew the protection. So some of these bullet points are actually raised in actual litigations where parties were saying, well, maybe I took it, but it wasn't really a trade secret. Do you have a policy defining and protecting confidential information? Is there password protection and encryption on your computers that contain your information? Do you require employees to sign NDAs? Do you train employees in confidentiality policy and how to safeguard the policy from talking to third parties? Is there unfettered access for all kinds of employees throughout the system to files and computer systems? What do you do with departing employees? Do you force them to return their laptops and all their materials? Do you take measures for departing employees post-employment to return all the information? Do you conduct exit interviews, strip the laptops, cell phones, things like that of all this information? So there could be a look back in a lawsuit where somebody took something and maybe using it, and a court may listen to a defense that you didn't take enough precautions to protect it to be protectable under the trade secret laws, federal and state. Another defense is that it has no value, because all of the trade secret definitions say something of economic value. And this comes up most often in the situation where you're using something, but it's very hard to pin down. It's like a shortcut or a secret, or maybe it was an idea that was created and put into a white paper, and it was never used, but you spent a lot of money and effort to come up with these ideas. So sometimes people will take materials that have been mothballed or even processes and other things that aren't being used presently. And sometimes there's a question of whether they have economic value right now. The other issue is whether somebody's acquired a trade secret, whether it was through improper means. Now, a fundamental issue of trade secret law is that if what you're putting out in the public domain can be reverse engineered, then it's not a trade secret. So there are things, a lot of products will have software code embedded in the firmware, and that source code of how you get it to work is not accessible. So you are protecting that. But any physical device you send out there into the public arguably can be copied without violating the trade secret laws. There may be some contract provisions that can reach this, like a non-compete for a period of a year or more, a couple of years, that says you can't even work in this field. But the other is independent derivation. If the party in question or the third party employer can prove that it may look like a duck and quack like a duck, but it's our duck. We made this ourselves. We have proof. One of the things on the flip side, if you're one of the parties, an employee who, an employer who's hiring over an employee from another firm, and you want to do this cleanly, and you want to develop a product that competes with them, and you want to avoid the appearance of some impropriety, of some possible theft, you can create what's called a clean room, where you wall off that new employee from the people that are working on this new product development, and to create a paper trail of evidence showing that even the end product that comes out is in the same field. We didn't use this guy for this. We walled him off. We have this clean room of people who are not infected by him. And that's a very common thing in software. A rarely used thing that's been codified in the Defense of Trade Secrets Act is that you might have a privilege to use, acquire and disclose trade secrets if you're a whistleblower and you're pointing out some crimes to federal, state, local government, or an attorney, or a complaint filed under seal. I'll never get that up and down thing right, Lily. So again, trade secret cases, which is maybe the most common part of the civil actions on data breaches, is the direct versus circumstantial evidence. It's very hard to find evidence, and you're usually looking at circumstantial evidence and against people who are denying it, and you're trying to patch things together. You don't often find the smoking gun. One thing that in the proof is that a trade secret does not include a person's aptitude, skill, dexterity, his manual or mental ability, and such other subjective knowledge as he obtains while in the course of his employment. So that you have to distinguish between, if you train somebody for 10 years about how to use a certain mold type of machine, an extruder, a lot of the stuff they learned is just not going to be your property. And sometimes you have to parse that, and it's very complicated. The inevitable disclosure doctrine holds that if the person knows so much about your business in an area and is going to a direct competitor who makes the same product, very close, it will be inevitable that she will use that trade secret information, and that can be mounted as an argument. Copyrights, I'll fly through that. You can bring a case for federal copyright infringement if it's code or some copyright material like training materials. You have to register the copyright before you bring the suit. There's different types of, there's direct copying, and then there's, in the case of software, for instance, you can have literal, just line by line copying of code, or you could have the structure, sequence, and organization, more the way the architecture or the organization of the materials. It's not exactly copying a word for word, but it's copying the juice of it. The DMCA, the Digital Millennium Copyright Act, adds a little bit of strength in the case of software and electronics, because if that person who absconded with any of your data, your software, also messed around with passwords or encryption or deleted copyright information, you have an additional way of going after them for money. The Computer Fraud and Abuse Act was originally a hacking statute, and it's been developed now. It's been used now in civil cases where there's been a breach of your data, maybe a theft of your data, or sending of programs out to third parties, something that's led to an interruption of service or other damage to your systems, but maybe you don't have enough information to identify it specifically as a trade secret. Maybe they just messed around with your system and they took a bunch of key data out that interrupted your service as something like a hacker would do, but it could be an employee too. So the CFAA will reach those kinds of claims, and it's a shortcut. You don't have to go through the elaborate proof you do for trade secrets. And if you don't have a contract clause on it that you can effectively use. Accessing a protected computer, any computer connected to the internet, it could be a cell phone, it could be a server, without or in excess of their authorization. If they're an employee, they already have some authorization to obtain something of value with over $5,000 in damages, which can be the forensic analysis cost, it can be the diagnostic measures for testing, or the investigators or employee type, or the remedial measures. So this is any damage to a protected computer, means any impairment to the integrity or availability of data, a program, a system, or information. It could be trade secrets, but doesn't have to be, and that's why this could be advantageous. The pending issue before the court, the Supreme Court right now, we're following, is whether if you have a lawful access to a computer or a server through passwords, and you're supposed to be in this area, and you go out into other parts that you weren't supposed to be in, or you misuse your access to collect data that you're not supposed to be collecting, have you exceeded your access, or is this just with no access at all? And the Supreme Court's looking at a dispute in the circuit courts about how far this is going to go, and whether any unauthorized access beyond your stated level of authorization can be a violation of the CFA, or does it have to be something closer to hacking, where you actually, broke through an encryption or stole someone's password? If it's broad, it's going to bring in this claim in a lot of these actions. The last area I have here is, there's some catch-all areas. I mean, you have your breach of contract, you have all kinds of trade secrets. If you're not sure the contracts fit, if you're not sure there's really a trade secret and all these proof problems, and it's really kind of a data hacking, you can go with the CFAA. But even if things slip through the cracks there are still other causes of actions. We will, if we have an appropriate state consumer protection unfair competition clause statute, we can throw that in there. Massachusetts has a well-known Chapter 93A, which if proven, has an unfair competition aspect of it, which if proven gives you triple damages and attorney's fees. Straight negligence, if what they do interferes with contracts with third parties, you can have a tortious interference. If they're relatively senior employees, you have the breach of fiduciary duty to the company, or a breach of loyalty to the company. There are even references to very old-fashioned types of claims like trespass to chattels, which is just this idea that a trespass to some physical personal property you may have. We've even been involved in a case involving alleged stolen software that led to a civil RICO claim, contending that there was criminal copyright, criminal trade secret misappropriation, part of an enterprise of multiple parties, and that this amounted to a RICO violation, which is, usually thought of as a mob kind of operation. But there's a variety of ways of slicing the onion to get at the offending parties. And I hope this is a useful summary of some of the core issues in that area. So at this point, I think we could turn to some questions if there are any.
Yes, we have been getting peppered with all sorts of wonderful clarifications and hypotheticals. I don't know if we'll be able to get to all of them, but we'll try to get to as many as we can. So we had, I think the first question that came in was how to deal with social media posts with employees. I think this is a great topic to cover in employee handbooks. Again, making sure that employees are aware of what behavior is expected and what their duties and obligations are to a company. That's sort of the preemptive thing to do, right, is to get everyone on the same page on what behavior falls under, authorized under an employee agreement and what's restricted. Once a violation has happened, assuming there's a friendly relationship, the hope is that, an employer and an employee can just kind of work it out between them. But barring that, Often these social media platforms have their own complaint and dispute resolution procedures. So if data that, if information that the individual did not have authorization to post was posted, most social media pages actually have a terms of service or terms of use that say, hey, you're representing and warranting by posting information to our platform that you have the authority to do that. So if you lie to us, we can take it down. So usually there's a takedown procedure. But great question. We also had a few questions come in on, I'll try to summarize it as best I can, but the situation of what happens when you have a group of people that are planning on working together on a project, and before the partnership even kind of comes to fruition, before something even goes live, someone goes rogue, takes everyone's ideas and launches their own program. So, I'll speak a little bit to what can be done maybe preventatively, and then maybe Howard can speak to what actions you might want to think through taking once that has already happened. So proactively, anytime you're talking about going into business with someone else, whether you're an individual or your own business, look at having non-disclosure agreements and other sorts of formal written writings in place before people start exchanging information. It's really important that everyone gets clear on what the intentions are in terms of who's contributing what, who is going to own what at the end of the partnership, and ideally, if something goes wrong, which when everyone's getting along is never really a thought, how the contributions are going to be divided up. Howard, do you have any thoughts on what to do if maybe you have a group of people working together and someone goes rogue and takes everyone's contributions and just launches their own thing?
Yeah, it's obviously in the absence of an agreement, you would have to consider a cease and desist letter and potential causes of action for misappropriation of something, of confidential information, trade secret. There can be breaches of implied contracts, even in the absence of a written contract. It's not a one-size-fits-all kind of case. I think it depends on the nature of the information, how proprietary it is. Some of it would be, caveat emptor, if you don't have an agreement and you're disclosing ideas to third parties and sharing them without any written or the situation has an implied duty of secrecy. It may be that you don't have one. If you go to a restaurant and you just start telling somebody your ideas, they don't necessarily have a duty to keep confidential. So it depends on the scenario, but there are implied contracts that I'm going to disclose my ideas to you, and the implied understanding between both parties is that you're not allowed to use it without me. That you can have a cause of action for that. I think that's kind of the situation. That's a situation where I prefer like a follow-up with more details, and then we can sort of iron it out.
Right. And I think the person setting those questions will follow up offline on some of these topics in a little bit more detail. Someone asked for a little bit more information on what's meant by a breach of a duty of loyalty. I think that this is, Howard, you're more knowledgeable than I am on this, but I think that this isn't sort of a general duty, right? This is reserved for sort of high-level officers in an organization.
I think the way a high-ranking officer, manager, director has a duty of loyalty from an economic perspective of not favoring taking action that would help his separate company or his brother's company economically. And so this comes up when that is the employee who is leaving to start another company or join another company, and also bringing along with him some information. Sometimes it involves going and getting a big contract that your former employer was, far along down the in trying to obtain. So it's taking a sort of, it's like acting in an economically disloyal way to your current employer. And again, that duty only arises in certain principles.
All right, well, I don't know how it's possible, but I think we actually managed to cover most of the sort of related questions that came in. Howard, could you share the last slide just so anyone that wants to has our emails available? But certainly if you have any questions on these topics that percolate after our webinar, please feel free to get in touch with Howard and I, and we'll look at whether it's something we can guide you further on. All right, thanks everyone.
Bye-bye.